Alder Close. Alder Heidemann. Alder LaFave. Alder Mitchell. Alder Menzer. Alder Perella. Okay. Alder Decker. And Alder Rust.
All right, good evening, everybody. Thank you for coming and for this committee of the whole with a town hall twist. We will have the TID present, our presenters. I think we have 2 or 3 of them present, and then the alders will be able to ask questions, and then from there we will allow questions from the attendees. 1 question with a follow-up, and you will have a 2-minute limit for each. So without further hesitation, we'll go into our presentations.
Hello, everybody. Can you hear me? My name is Kayla Thorpe, and I'm a municipal advisor with Ehlers & Associates. We are a public advisory firm working across the Midwest, primarily in Minnesota and Wisconsin. Our firm has been engaged with the city dating back to 2010 on both economic development and debt issuance, and we have been working over the last few years on most of the TID creations here in the city. What I'm going to go through is kind of our TID 101 that starts off just some basic concepts and an understanding of how TIF financing works, what it is, what's the intent, some history. And then I'll turn it over to Attorney Brian Winters, who's the city's development attorney, and talk about how development agreements are negotiated and structured here at the city. So slow me down, I tend to talk fast, but I will be happy to answer questions afterwards. What is tax increment financing? And so you'll hear 2 common nomenclatures used when we talk about TIF and TID. You can use them basically interchangeably, but tax incremental financing is the financing mechanism, the tool, and the tax increment district is the physical boundaries of the district that are developed. This is the most powerful economic development tool available to municipalities in Wisconsin, and it allows us as municipalities to capture the incremental growth and that incremental property tax revenue in that defined district boundary for projects that will directly benefit that boundary, and that could be public infrastructure and development incentives and kind of those administrative fees that go through those TID districts. How this works through statute as the cash flow, and I think I have yes. At the time of the district creation, and this is for all districts across the state regardless of type, and I'll talk about type and time frame in a little bit later, but regardless of type, this same process works for all of them. At the time of the district's creation, so we're going to go way back here, the baseline property values contained within the district, so whatever the value of the property within the district at the time of creation, and the time of creation is the day of the council's action to adopt the resolution to create the district, they are frozen in time. And that value, the property taxes generated on that value, are still distributed to the overlying taxing jurisdictions, meaning the city, the county, the school district, and the technical college, as they would traditionally be distributed today. So there's no difference on how the property values today, how those taxes are distributed to the taxing jurisdictions at the date of creation. Now what happens is as development occurs, redevelopment, new development, and property values within the defined boundary increase, that's what we call increment. And we capture the equalized value of that increment, and the taxes collected on the value over and beyond that frozen base value, those are the tax dollars that are put back into the district to pay for project costs. And now the time frame in here, depending on the district, could be 20 or 27 years. depending on the defined district. And then when it's time to terminate the district, all of the value, baseline plus increment, is put back on the tax rolls, and all of the taxes collected on the entire value are then distributed back to the overlying taxing jurisdictions as they would normally be. And so this just kind of shows that the tax rate does not change whether you're in a TIF district or whether you're out of a district. The allocation of your tax dollars change based on the appreciation or new value. And that's just kind of recaptured here, is that this value over and beyond the baseline property values, that's really what we're talking about as the financing mechanism. It's the growth after the district is created. And so if we're talking about a greenfield site or even a larger district like TID, I think TID 21 has 1,000 parcels in it or something like that. We're talking about all of that natural economic appreciation and all of that development appreciation. All of that value is calculated and captured in the district, while that base property value is still being distributed to the taxing jurisdictions. Now, why is this a powerful mechanism in Wisconsin, and why do we see it more and more? It is one of the only economic development tools available to municipalities to spur and incentivize development within a community, and it really requires cost participation amongst all taxing jurisdictions. Because all of that increment collection, that tax collection, is being foregone by the taxing jurisdictions during that life of the district to be pumped back in the district for their eventual end benefit, but it does require a collaboration with all of those overlying taxing jurisdictions. It addresses a lack of other incentives and financial resources available to municipalities. I won't go too far down the levy limit train, but there are some severe statutory constraints on municipalities for their ability to raise property taxes or raise their property tax levy to address financial development incentives or development spurring activities outside of the use of tax incremental financing. And primarily is used to promote economic development, and more recently we're seeing a lot of economic redevelopment within our communities, that at the end of the goal at the end of the life of the district is to have that significant increase in value, and then every taxing jurisdiction benefits from that in the end. And was really kind of created in the mid-'70s recession to counteract the economic downturns and helps communities stabilize economic development during uncertain market times. Just a little bit of history about TIF in Wisconsin. It's an original program dating back to 1975. So this is not a new phenomenon. This is not a new concept. This has been a widely and popular used tool by most communities dating back to the 70s. As of January 1st, 2024, in Wisconsin, there was $41.2 billion of incremental value contained within districts across the state. It's about 4.5% of all of the value in the state of Wisconsin was within a TIF district. And as of April 2024, there are 1,400 active districts within the state. And I'll just kind of go back and highlight this. This is dating back from 2000 to 2024. The blue is the base value of every parcel in that time created or contained within a district, and the orange is the incremental growth within those districts over that period of time. And so you'll see that there's almost in 2024, $15 billion of base value and about $60 billion of incremental value over that period of time. So it really shows that the district creation and the mechanisms that are allowed to municipalities through this tool are really spurring growth, and pretty rapid growth over the last decade. There are a number of statutory requirements, and that's why you'll see these things pop up on a number of committees. First, no municipality may have more than 12% of their equalized value contained within a district at any point in time. That is part of a project plan requirement. You will see that test as to what is the equalized value of the community, what is the equalized value of all of the underlying taxing jurisdictions, And when we create a new district, we also then must include the base value. It's a 12% test. It's a pretty easy thing to go through, but it is contained in all of the project plans. Boundaries must be contiguous and cannot extend beyond corporate limits. And so using right-of-way is a common tool to get contiguous boundaries. And also, you can't create a district until you've annexed land into the community. We see this a lot, especially in the Fox Valley area, where farmers are starting to get out of their business and want the city or county or village to take on their property and annex them for future growth for the use of a TID district. And there's other requirements of maximum life that apply per TID type. And we can kind of take a look at those right now. The 20-year max life districts are mixed use and industrial, both of which Sheboygan has utilized and has active districts that are that type. You must meet a 50% proposed test, of which 50% of the land within the district either must be suitable for mixed use, which is combined industrial, commercial, and residential, or for industrial, it must be zoned and suitable for industrial use. For blighted, it must be blighted, and unfortunately, this is a very vague term and is not defined in statute, the term blight. So it really is up to the community to define blight and be able to support that in the project plan. Conservation or rehabilitation and environmental remediation are two lesser used, and it is really needed to have brownfield sites made green, to remediate any soil or building contamination, to remove buildings that have been used for purposes that are no longer suitable and that may have contamination in them. And those get a little longer period to recoup those costs. Those are 27 years. One thing we hear a lot about is residential development within TID districts and their use and how much and kind of the vagueness around that. The only type of district that allows, under statute, residential development is mixed use. And there's this kind of misunderstanding, vagueness, again, not defined in statute as to what newly platted residential is. Really easy to define when we're talking about a farm field that was brought in. That was never platted to be residential, and so that must not exceed 35% of the value in the district. But when we're talking about redevelopment areas that have been platted and may be platted as mixed use or mixed commercial, we can kind of get into some back and forth with both properties within the district, councils about what is the 35% newly platted residential and how is that defined. But anything that has been previously platted as residential, meaning a legal plat map adopted for that land, can be contained within a mixed-use district. There are a number of project plan requirements that is required under statute to be approved by both the JRB, the Plan Commission, and the Council. Those are project costs, identifying what dollars are going to be spent in the district, and this can be phased in or laid out in a pattern that matches the revenue stream. And that really comes into play when we talk about districts that take on debt. We must describe the costs and what they're going to be used for, and whether they're going to be redevelopment or active development within the district. We also must have a cash flow forecast, and this is kind of the crux of, if you look at one page of the project plan, that's the page you should look at, because it's going to kind of give you a general idea from start to finish of the district, what is the revenue coming in and what are the expenses going out. And that's really where we build in our financing plans, whether that's the city taking on debt to complete capital projects within the district, or whether that's a reimbursement on a pay-go basis to developers. And we estimate that based on an equalized tax rates to districts. The increment collected, meaning the tax generation revenue, is calculated on an equalized tax base, not on an assessed tax base. So if you're looking at your tax bill and then you're looking at a TID cash flow, those tax rates aren't going to be the same because your tax rate is assessed on your tax bill. But as far as the mechanism to fund TIF districts and how we need to show it, it's on an equalized basis. And the but-for test is really the statutory deadline of what all of the taxing jurisdictions need to agree to on the JRB side, the council and the plan commission is, but for the development being proposed, but for the creation of the district, the development being proposed would not happen. And this is really important to highlight that it is the development being proposed, not development as a whole, not development in different forms. It is specifically the but-for test needs to be met on the development being proposed. And that is the key finding. You must meet the statutory requirements to find that, and it would not be as proposed within the same time frame and the same level of value of the project that is driving the creation of the district. So again, I just want to re-highlight that it is but for the creation of the district and the use of tax incremental financing, the development being proposed would not happen within the same time frame and the same value that is currently on the table. And how do you prove it? There's third-party independent reviews of developers' sources, uses, and cash flows. This is a service that we do internally here at Ellers. We work specifically hand-in-hand with developers that are looking to come into communities and have districts created to do a full analysis of their operating pro formas, their construction costs, their independent financing, the investors they're bringing to the table. And then we kind of do an industry standard of what is their internal rate of return, what is their external rate of return, and how are they meeting that with and without TIF assistance. And that really is a best practice to go to prove to all of the committees that need to approve the but-for test that they need the tax incremental financing to make the development work. Also, if there's a challenged site, if there is remediation, if there is possible contamination, if there is a legal settlement that is having to be met to develop that land, that is for the but-for test, because it is but for that development needing to happen in a one specific way would not happen without the creation of the district. There's extensive public infrastructure costs, and when we start talking about industrial areas or large development areas, this is primarily what you will see the largest expense of a district being, is those public infrastructure costs to either bring utilities to an area, upsize utilities, or make sure that plants, meaning wastewater treatment plants and water pumping stations, can handle the additional flow that would be required because of the development. There's a lack of economic development within the community. Like I've said before, this is one of the only tools available to spur economic development, and there's other extenuating circumstances that may play into how the community can justify the but-for test. But ultimately, at the end of the day, it is the JRB requirement to meet this test up front. And the Joint Review Board is a member of each of the overlying taxing jurisdictions. And so there is a member appointed by the school board, there is a member appointed by the county, the technical college, there is a public member, and then there's a city representative that sit on that committee, and they must adopt the resolution that satisfies the but-for test. I've kind of laid this out in just talking through this, but there's a procedure. We must have the feasibility study as part of the project plan to show that the increment collected throughout the life of the district can support the project costs that are estimated to be. The first stop at this plan is the Joint Review Board. It's an initial Joint Review Board meeting to introduce the project plan, introduce the process, kind of opens the door to the community. It then goes to a public hearing of the Plan Commission. The Plan Commission will then adopt a resolution that approves the boundaries and the project plan and the creation. That then goes, after Plan Commission public hearing, to the governing body approval, and that action date is the creation date of the district. Then after the council's action, it goes back to the Joint Review Board to affirm the resolutions adopted by both the Plan Commission and the governing body. After all of those have been met, it then goes through a state review process in which you have to submit all of these, about 8 different maps, the project plan, all of the signed resolutions, all of the minutes of each of these meetings has to go to the Department of Revenue for approval and certification of the based values contained within the district. There are quite a few people involved in the process to getting to the point of council action. There are municipal or development attorneys like Attorney Winters who review development agreements, review developer proposals, and will also write a letter that is needed as part of the project plan, basically a legal opinion saying that the project plan meets state statute requirements. The Joint Review Board members are an integral part of this and understanding what their taxing jurisdictions are foregoing. There's always a chart contained within the project plan which will show on an annual basis based on our cash flow of what those annual taxes would be. And then people like myself, municipal advisors, we help coordinate all of the meetings, and then we help coordinate and draft the project plan. Just to highlight some eligible project costs, things that could be paid for from the district is public works and improvement projects, like I mentioned, large infrastructure. Financing, meaning most times that the city will take on debt, general obligation debt, to pay for that infrastructure up front, and then you'll pay the principal and interest over the life of the district. Real property assembly, meaning any property acquisitions that need to happen to facilitate projects. And there's a land write-down provision in the statutes that allows the municipality to recoup the difference between what they purchased the land for and what they sell the land for. It's called the land write-down, and that is an eligible project cost for the municipality to recoup those costs. Professional services, like municipal advisors, attorneys, audit. There are audit requirements at the beginning, middle, and end of a district life. Any administrative and organizational costs, contributions to a community or redevelopment authority to initiate facade improvement programs, revolving loan programs, those type of things. Relocation of utilities and or buildings or businesses that may be needed. A prorated share of utility infrastructure that not only benefits the community or the district, but the community as a whole. And you can think of that as if we need to upsize a pump station to facilitate the growth within the development or the district, but also serves outside of the district as well, we can allocate portions of those costs back to the district. Any cash grants that are typically referred to as development incentives would require a developer agreement with the municipality. Any environmental remediation, and then projects within a half-mile of the district. The test to be met for those half-mile projects are they must have benefit to the district. So again, like a utility pump station that may not be located in the district but serves the district is an eligible project cost. There are a number of prohibited project costs that cannot be paid for by a district. You cannot construct or enhance or expand municipal buildings that aren't facilitating a utility-driven utility to the district. You cannot finance facilities that are 100% financed with utility user fees, except those upsizing activities to meet the demands of the development. Any general government expenditures unrelated to the TID, so no police, no kind of parks programs or anything can be paid for through the district. And then anything associated with newly platted residential, except in a mixed-use district, is not an eligible project cost. All TIF districts in Wisconsin are allowed to be amended, both on a boundary process and a plan process. There are 4 boundary amendments that are allowed through the life of the district, meaning you can add or subtract parcels of the district. But they must remain contiguous, must follow the 12% test. You can also have an unlimited number of project plan amendments, and that's really where you would amend if there's a project that comes up halfway through the life of the district that needs to be added to the project plan that wasn't originally in it, or there needs to be a revenue sharing opportunity between districts. Number of districts can, if there's excess increment or overperformance of development in one district, they can share revenue with another district to either get it off ground or help it positively cash flow. The process for a boundary amendment and a project plan amendment are the same procedure as the creation. There's an expenditure period after which you can expend dollars up into a point that ends 5 years prior to the maximum termination of the life of the district. And all of those costs can be entered into prior to, so anything that is contractually obligated, debt service or ongoing administrative costs can extend past the expenditure period, but you can't authorize new projects after that expenditure period has ended. And like the maximum life requirements that I talked about before, I'm not going to regurgitate this all to you. It's either 20 or 27 years. When you close a district, if there's remaining funds, like the remaining fund balance, those remaining funds are distributed back to the overlying taxing jurisdictions based on their proportional share of the tax bill. If there is a deficit, meaning that it's in the red, that is the city's obligation to eat. The other taxing jurisdictions are not obligated nor can contribute to any liabilities that still may be left at the end of the life of the district. Now just a few quick highlights on how the financing products work within a development district. There are a number of ways, and Attorney Winters will go through what kind of the city's policies are when negotiating with development agreement or developers, and what the city will and will not put on the table. One way to finance projects is the community will quote-unquote front the cost, usually through general obligation debt or revenue debt, or advances from other funds. You will see traditionally small advances from other funds in the first 2 or 3 years of the district, because there's no increment being collected to pay for those costs. So a lot of our community clients will front costs, meaning the creation costs, because there's filing fees with the Department of Revenue, there's all these attorney fees and things you have to pay for, and then they'll be recouped through the life of the district once there is increment being collected. The most popular way and the less risky way to finance projects is on a pay-as-you-go basis, meaning as the district starts to generate increment and collect taxes on that increment is then pumped back in to pay for project costs or finance the developer incentive. So this is a really important thing to highlight, is that as the developer or as the district is collecting revenue, meaning tax dollars from the developer on a pay-go basis, that is what's given back to the developer on a development incentive. Only if there is tax generating increment. So when I'm sure Attorney Winters will highlight it, if there's no performance by the developer and they are not paying taxes into the district, they are not getting anything in return. That's what is a pay as you go. As the developer pays in, they get back on the agreed upon amount. The municipality will fund through debt or advances, can use the revenue to repay the debt within the district. And the municipality bears that entire risk on the debt if there's insufficient revenues in the district to pay the debt service requirements. But provisions of the development agreement can be agreed upon to mitigate that risk, and specifically minimum value guarantees to ensure that tax generation within the district at minimum pay for the debt service. Talked about the pay-as-you-go. This is kind of just a visual to get an understanding of how that process works that I talked through, is that as the developer pays into taxes into the district, that creates the incremental value, which creates the tax increment revenue. The city then collects that revenue from the new increment generated and then reimburses the developer to pay for eligible project costs, or within the TID as a whole to pay for eligible project cost. And then there's some provisions of developer agreements that are recommended and agreed upon, and again, Brian Winters will go over that. Letters of credit, performance bonds, mortgage liens, personal guarantees. There are a plethora of options available to municipalities to protect their risk and protect the overall taxpayer within the community from bearing responsibility for some of these things should development either be slower than expected or not happen as agreed upon.
Hold on. So we have a tornado warning right now.
Oh.
So well, hold on. We're in the safest part of Uptown Social, but I just want everybody to be aware that that's currently happening, and I believe, I think we can continue. I'm just letting everybody know that if lights go out, it's a warning. That's why you hear the siren. Yes, but I'm letting everybody know that that's currently happening, and we're in the right spot for Uptown Social.
I appreciate that.
Yeah, but you can continue. I'm just letting you know.
That was really
If you don't feel comfortable, you're free to leave, but as of right now, we're going to continue until either the power goes out or we don't feel comfortable. As far as I've been told, we're fine right now, so we're going to continue with the presentation. Thank you.
And so this is where I'll kind of wrap up as to at least getting through the portion to which you get to finance these projects and get to a development agreement. The development agreement with specific developers is one of the most integral things that plays into the creation of a new district and really hedges the community's risk and protects the community as a whole. And so I'm going to stop here and I'm going to turn it over to Attorney Winters, who will take it and kind of talk about how the city deals with development agreements and negotiates those as a whole.
Thank you, Kayla. Good evening, everyone. How are you all? Thank you for joining. The warning kind of stole a little of my thunder. I was going to thank everyone for showing up and braving the elements. If my car's not there when we come out of this, I might need a place to spend the night. But thank you all for coming. It shows how much you care about the city and the development within the city. We care a lot about the city. I was appointed as Special Development Counsel for the city in January of 2023. And we've done a bunch of great things and hope to do more. And my job was going to be to kind of walk through kind of the protections that we have put in place for the city. And you've seen this. We borrowed this from Ellers. The one thing I just wanted to point out and make sure that we talked about or was really highlighting is we're really talking about this part right here. Okay, this baseline value, which, as Kayla very accurately mentioned, is there, will continue to be paid and will continue to be distributed out as it always has been, as if nothing had changed. What we're dealing with and what we're talking about is this incremental value, this increment that's generated by increased property values, okay? With the hope and the plan that at the end of the district, we have all of this new increment that's now on the tax rolls and all of the different taxing jurisdictions are experiencing all the benefit from the additional development. So I just want to go through the TID life cycle real quickly. I think this is a good example to kind of show exactly what that prior slide means. So as an example, pre-TID creation, you have this agricultural land, it's 40 acres, and it's assessed at $500,000. I'm just using round numbers just to make it easy. The annual tax revenue at a mill rate of $10 per thousand would be $5,000, of which it gets broken down as shown over here between the different taxing jurisdictions. Then you have the tax creation, and during the life of the TID, the value presumably is increased as the development happens on what otherwise was just a raw piece of land. So a building, whatever may be put on the land, that improvement will then be assessed, and then for the purposes of this example, it's assessed at $10 million. So what you have is an initial baseline value of $500,000, and then you have an assessed value with the completed project of $10 million, okay? And so that's an increment, that's the additional, that's that part of the triangle above the base, or that triangle above the base, of $9.5 million of additional tax revenue that was not there prior to this project, and is there because of this project. Again, with the locked-in base rates, the annual tax revenue to the underlying taxing jurisdictions is still going to remain the same. It's frozen, okay? But you have now this tax increment each year, and potentially, and that will vary from year to year depending on what the value is, what the tax rates are. But you have increment in our example here of an additional $95,000, and that's the dollars. Those are the dollars that are getting put to work to incentivize the developer to make the development, to take the risk to make the development. And as Kayla mentioned, that's all under the structure of this but-for concept, that but for this development at this time at this scope, without this incentive, that development would not happen. And that is in every one of our agreements, that but-for concept, and the developer represents and warrants to that. But this $95,000 is what's getting returned in some instances partially back to the developer to recoup their costs that they're putting in to make the development happen. Again, just real quickly, after the TID closes, you still have that $10 million, But now you have an annual tax revenue of $100,000. You have 5,000 or you have 100,000. And this may be 20 years and maybe 27 years. It doesn't happen overnight. But at some point, it's going to come back on the tax rolls. And look at the difference between these numbers for all of the different taxing jurisdictions. That's why I'm so excited about TID and TIF and why it's such a great tool for municipalities to use to develop the property and their assets that they have in the city to, expand employment opportunities and expand the tax base, give people jobs, give them opportunities, and just making the community a better place to live. So I have a lot of items here. What I wanted to do is go through the noteworthy provisions that we include in our tax development, our TID development agreements. And these are all designed to protect the city. My whole goal is to protect the city at all costs, okay? And so when we're negotiating with developers, when we're drafting development agreements, our main focus is how can we make this as little to no risk on the city as possible. And so I wanted to just mention first the key definitions that we use in our development agreements to make sure we're all kind of speaking the same language or understand how these pieces will then fit together. So we have property, which is the real estate for which the project is going to happen on, okay? And that is subject to the development agreement. We will legally define what that property is to determine, okay, this is the piece of property, we know what the tax value is on it, we can see what the increment is as the taxes are paid and assessed and paid, and that property is what's subject to the development agreement. The project will list the scope and timing of the development. So it'll say this is what the project is, and we try to get as detailed as possible to hold the developer's feet to the fire. We're not just going to say build a residential development. We're going to say 45 units of this or this size apartment complex to really make them give us what we're anticipating we're getting in this bargain, okay? And so we'll describe the scope and we'll also describe the timing. So if it's phased, how many years, what are we talking about? What's the deadline to be able to make sure we know and we're getting the return on our investment of doing this deal and making the development happen. Developer improvements, that's pretty much line by line describing the things that the developer's committing to do for the project, whether that's obviously building the building or whatever the project is, landscaping, utilities to the extent that there are any. That developer improvement definition will define all of the various things that they're committing to do with regard to the project and the development. Guaranteed value, Kayla mentioned this. We have it in all of our deals. I don't think we've done a deal without a guaranteed value yet, as far as I can remember. What the guaranteed value does is makes the developer say, I guarantee X amount of dollars will be the value of this project will be X number of dollars. And that guaranteed value can be equated to a taxable return because you have this value and this means this much in taxes. We know how much is coming in, and that we can use as the baseline to determine how much either incentive we give or to really protect ourselves and say, okay, well, we have a guarantee. These are personal guarantees. This isn't just some shell company that its only asset is the property. We have personal guarantees from folks, or maybe the mothership company that has a lot more assets. But we're getting a guarantee that this is the value you're going to get, city. And guess what? If it gets burned down, I got to build it back up and I got to provide that same guarantee, because if it's not there, I have to come out of pocket and make that payment as the developer. So whatever the payment would have been had the value been what they're guaranteeing it would be. So again, protecting, mitigating risk, and protecting the city is our main goal and focus. Tax increment, you saw that on the first slide. Available tax increment, this is the term that we like to use, or what we use in our development agreements to say, okay, there is that tax increment, going back to this slide, there is this tax increment here. You developer are not going to get all of the tax increment. You're going to get the available tax increment, and we define what that is. Typically, it's a percentage of the tax increment that comes in, or less. What I have here is the next definition, priority project costs. So if the city is taking on costs, whether they're putting in the infrastructure, they're taking out debt, they have legal fees for fantastic attorneys, all of that kind of stuff can get wound up and put into this priority project cost definition, which comes out before the developer gets its portion of the tax increment, okay? Another key definition, shortfall events. So in the event that they don't hit their production, they don't hit the size of the development that they promised, and that means they don't hit that value that they're guaranteeing. That's what's called a shortfall event. When there's a shortfall event, then you have a situation where, again, as I mentioned, they're going to pay the difference of whatever taxes they would have paid had they met that guaranteed value. Then finally, MRO, that's short for municipal revenue obligation. And what that is, think of it much like a note, except it's a note that's only payable off of revenues that they pay in their taxes. They, the developer, pays in their taxes. That's sort of the primary funding mechanism that we have in our incentive packages. I did already mention the but-for test. If anyone has any questions on that, happy to answer it. But basically, but for this project with this scope within this timeline, the developer would not have done it but for having this incentive package. It just wouldn't have happened. It wouldn't have made sense for them from a market perspective, from whatever they determine as they need to get themselves to do this deal. Second, property, so these are all representations of warranties that are in our development agreements. The property is to remain taxable, okay? And why that's important is because we need the taxes to come in to pay for to generate that increment and to be able to do all the things that we want to do in the TID. So there's no tax exempt use permitted. Also, we don't allow them to challenge property tax assessments below the guaranteed value. Again, there may be a situation where the developer's trying to pay less in taxes. Well, that's great, but you can only do that up to the guaranteed value. You cannot go below, because if you do, you're going to have that shortfall payment anyway. But we also just don't allow them to challenge it below the guaranteed value. Timely completion of the project. Once they start, it's without interruption. Obviously, there can be force majeure events. A tornado comes through, but basically, short of something like that, timely completion of the project, we hold them to those standards, but whether there's phases or whether it's just a completion time, that's always in the agreement. We require compliance with all laws, codes, ordinances. We do not cut corners. We don't agree to say, yeah, we'll get this through this committee or that committee. They're doing it just like everyone else would have to do in compliance with all the laws, rules, regs, ordinances, and we make it very clear in there that we're not agreeing to make any changes or to give them any additional benefit because they've entered into this agreement. They still have to go through all the hoops as anyone else. Also, we get information about their insurance and also their ownership information. So insurance, they'll have certain representations they'll make to make sure that they have sufficient, construction insurance or general liability casualty insurance consistent with sort of general practices. And then we also know who the developer owners are, which I think is important too, because you want to know who's on the hook. And why that's also important is because we have a provision in here that doesn't allow them to just change over who the developer is. We're entering into this agreement with this group of people because we want to work with them. We trust in what they're going to do. It's not okay, sign it up and flip it to someone else. So we get to know who the owners are. And that's important, again, protection for the city, which they can't assign the agreement, they can't transfer it to anyone else without the city's consent, which may be withheld for any reason. Payment of taxes, they agree to pay all their taxes. Again, just additional reps and warranties. And the reason we have these protections in is because we want them to represent that they're going to do all these things, and if they don't, it's what's called a default. And when there's a default, and we'll get to this, I have a slide, but basically everything stops and the city has no obligation to do anything. But again, we're trying to protect the city, and that default is a mechanism to do that. Required information, so this is what the developer needs to provide, usually earlier on in the process. Again, it's a default if they don't provide it timely. But they'll proof of title, that they own the property or that they are under contract to own the property, again, offer to purchase or whatever the document is with regard to that property, capital P, that we're using for the deal. The construction schedule, the commencement and completion dates, the construction breakdown and budget, the value upon completion, their estimated value upon completion. They have to provide us all the permits and approvals that they need to get the project done. Final plans and specs for the actual development, and then whatever financing and authority documents they have, whether through their bank and or through their LLC or corporation, as to proving that they have authority to enter into this deal and that they have the financing to back it up. City protections. So these, I wanted to list some specific provisions that we have in our development agreements that are solely designed to protect the city. Number one, district creation contingency. There's a situation where the district may not be created, but we're still in negotiations with folks to possibly have a project, or that project may spur on wanting to have or needing a new district. Well, we're not going to be on the hook for this development agreement if we can't create the district, and so that's where we have a provision in the development agreement that, as a contingency to having the city have to do anything, that the district gets created. It's out of the city's control. The JRBA needs to approve it and other things, and so we can't be bound to the agreement if we don't have that TID created. Property tax exemption and property tax assessment challenge restrictions, I mentioned that already. Property needs to stay on the tax rolls and be taxable, and they can't challenge those assessments below the guaranteed value. We, as the city, make limited representations on property for conveyances from the city. There's situations where the incentive may be that we're giving land or selling land at a certain price. My goal, and what we always do, is restrict the amount of representations the city's making. The property is given as is, whereas with all faults, which means you do your due diligence, developer. You have any issues, you make the determination. We're not making any representations that you can come back to us later and say, oh, there was this spill or that spill on the property, or was this, it was whatever could possibly come up on the property. You are taking on that risk and doing that due diligence, developer. Also, there's title insurance. And a special warranty deed. So the title insurance is paid by the developer, but it gives the developer title to, it insures the title to the property with whatever encumbrances or exceptions may be on there. And then the special warranty deed is a limited deed that's actual transferring or conveyance document that has restricted representations on it. It's not a standard warranty deed that would guarantee title per se. Commencement notice, that is a defined term that we use in our development agreements for the developer to say, I'm going to commence my development of this project, and we'll define what that means. That may mean footings and foundations, that may mean digging a hole, that may mean something, but there is some ascertainable standard that they have to commence construction by a certain date. And so we have that in all of our deals. If they don't meet that requirement, it is a default. Again, everything stops. We also have, in a situation where the city is conveying property, we have a reconveyance option, where if they don't meet something by a certain timeline or deadline, that they will be obligated to reconvey the property back to the city. That's one option. Another option is security for timely performance. So what we would get is potentially like a letter of credit saying, okay, you're obligated to build this by a certain time, or put these number of units in a certain time. If you don't, in lieu of giving us the property back, you have a letter of credit that we can draw upon and, in essence, make the city whole for the value of the real estate that was conveyed. Yeah, I think I hit on those two. Reconstruction of the project, I just mentioned this in passing earlier, but if there is a casualty event, fire, storm, something that happens and half the building is gone, they're obligated to reconstruct the project to the state and to the value that it was prior to that casualty. Okay, again, the thought is we want value created so that we can get the taxes paid by the developer and use that increment to finance the project and do other things we want to do in the district. Personal guarantee, I mentioned that. So there's personal guarantees of a guaranteed value by a guaranteed value date. We will have a guaranteed value date, a guaranteed value by a certain date and time. Okay, and so if they don't hit that value level by that date, that's where that shortfall concept comes in, and they're obligated to make up the difference of the taxes that they're obligated to pay and that they would have paid if they hit that guaranteed value date. Again, just protection and loss mitigation for the city. The city has access and inspection rights all along the time of the project, so, and that is for the city's purposes. It's not to make sure that they're meeting their plans and specs for their own purposes. This is so the city knows, hey, this is the project that we're getting, is what they promised and is consistent with their plans. I mentioned this earlier, city consent for assignments. We think that's key, that the city has control over who they're doing business with, and that it's not a kind of a flipped type of situation, or developer comes in, gets a deal, and then leaves. We want to make sure we know who we're working with, and we get that result and have that relationship for a long period of time. Wisconsin law will govern Sheboygan, and all court actions would be in Sheboygan County Circuit Court. So if we have someone from out of town, we have Wisconsin law governing, and we have the Sheboygan County Court being the one to hear the case. We will also record a development agreement, or what's called a memorandum of a development agreement. What that does is it makes an actual recording on that property, capital P property, such that anyone runs a title report, that will come up and it will show that there are obligations of the developer under the development agreement. A memorandum is usually a page or two that just says, hey, there's a development agreement out there, may list one or two of the obligations, but it's not the full development agreement, maybe 15, 20 pages. It's just a couple pager to put it on record so that everyone has noticed that there is a development agreement that applies to this property. And then finally, defaults and remedies, and that's what I'm going to get into on the next slide. But there are capital D defaults that the developer does something and they are in default, and then there are remedies that the city has in the event of that default. So defaults that we have, these are just sort of more general, but we have a failure of the developer to timely perform any obligation under the development agreement, and there's a bunch of them. But if there's any rep or warranty by the developer that is false or misleading in any material way, that would be a default. If the developer goes insolvent, becomes insolvent, or there's a receivership action, something along those lines, that's an immediate default. And again, everything freezes. The city has the opportunity or option to terminate the development agreement. They can suspend or terminate MRO payments. They can refuse to issue permits on the project. They can recover all damages, costs, expenses incurred by the city related to that default and the drafting and negotiation of the development agreement. The thought is if they're in default, the city has the option to make itself whole, and the developer is obligated to make the city whole. And then there's the sort of general catch-all of any and all other rights and remedies available to the city under applicable law. So we have these specific provisions in there, but then we also have the general catch-all. Basically, we can seek any other damages that we think are within our rights under the law. So that is what I have. Are we doing questions after, or did anyone? Okay. So thank you.
Good evening. My name is Kristen Fish-Peterson, and I'm with Redevelopment Resources. I was asked to speak about the development market, the temperament or the market out there for development right now. And what's relevant about my presentation is that our firm did the city's housing study back in early part of 2024. I do have a PowerPoint presentation. Do I have to? You should be next slide. Oh, the very next slide? Okay. There we go. Thank you. All right. The housing study that we undertook was meant to provide leaders with certain types of information. We wanted to discuss the function of market demand. We wanted to talk about the demand forecast, and we used job creation in there too, and I'll get to that in a little bit. We did an inventory of existing housing supply. We looked at housing costs and affordability at various income levels, current availability of affordable units at various income levels. We looked at the availability of single-family residents to accommodate large families. We looked at the existing or new supportive financing programs for housing development, and we did a gap analysis for the next 10 years. The steps that we took to do that, to provide your city leaders with that information, was that we gathered secondary data. I have a person on my team, we call her the data geek because she loves digging data. We also did stakeholder interviews. I spoke personally with many of the business leaders in your community to talk to them about their environment for hiring and what type of impact the housing market has on their ability to hire the employees that they need. That was very enlightening. We gathered demographic data. We analyzed the existing housing stock. We conducted a demand and supply analysis, and then we determined what the demand was and we broke it down in several categories. So you do have a growing population. You're one of the few communities that we've studied and we've worked with that has a projected growing population. We estimated a conservative growth, but we also went with a higher growth scenario because we understand the dynamic here in Sheboygan. You have a unique community in that your development market is very active. in all the communities in which we consult, this is probably the most active development market that we've seen in recent years. You have a lot of jobs being created, you have a lot of companies growing and expanding here, which puts a lot of pressure on your housing market for housing demand. This is an example of the employment growth by, these bubbles represent different industries, and everything to the right of the solid line down the middle is growth, and everything above the bottom of the chart is also growth. So your manufacturing sector is growing very rapidly. You also have growth in the arts, entertainment, and recreation, financial and insurance, construction, management, healthcare, and a few other smaller categories. This is a chart that looks like this in just about every community we consult. Every community that we look at, a majority of the housing was built before 1939. And then between 1940 and 1999, there was a pattern of growth that literally stopped between 2000 and 2009. And that stoppage, it didn't pick up for any community that we've seen. It's been stagnant. So many communities are behind the eight ball in the amount of inventory that's on the market for residents. Another factor that's impacting demand in many communities across the country is that seniors are staying in their homes longer. They're staying home, they're not moving into that retirement community, and that was evident when I interviewed the senior care facilities in your community. We also did the housing study for Plymouth just after this study. And when I talked to the senior care providers for nursing homes and assisted living, they said the average age 20 years ago for people to leave their single-family home and seek a retirement housing solution was 68 years old. Now it's 92. And so those homes are not being turned over to the younger generation for possibly a first-time home situation. Those homes are staying occupied by the senior population. Another interesting fact that I didn't realize is that only 5% of people die at home. So if you don't have a plan for where you're going when you get older, you at least want to talk about that with your family. That's my personal note there. As far as affordable units are concerned, fair market rent limits in 2023 are listed here for studio apartments or studio 1-bedroom, 2-bedroom, 3-bedroom, and 4-bedroom rental situations. When we inventoried the community by unit size and rent limit, there were hardly any units available at all. So if I'm a person who is in the 50% of the area median income, I can't afford to live in this community. There were only 5 2-bedroom units available and 1 3-bedroom unit available in a rent that was affordable to me. So what happens? These housing units get occupied by people who can afford them. So people are renting a cheaper unit that have a higher income because it's there. If you don't have rental units that are available at a market rate, those people who can afford a market rate are going to rent down and occupy a unit that could otherwise be available to a person who needs an affordable unit. That's what this housing ladder is indicating. This is a small type, but on page 25 and 20 through 27 of the study, we looked at occupations of people who make certain wages in the community, what's available to them, what kind of occupation they have. So for people who are cooks, helpers, teaching assistants, nursing assistants, packers and packagers, automotive and watercraft service attendants, miscellaneous assemblers, these are just some of the hairdressers, landscaping and groundskeeping workers, library assistants, security guards. Their employment, their wages pay them $13,390 a year. Their annual median wage is between $34,000 and $45,000 per year. There are 13,390 people in that category in your community. They could afford a 2-bedroom unit, but there were only 5 available in the community at that time. So you don't have the housing available to the people that are doing the jobs that are prevalent in your community. So we then put all of that information into a spreadsheet like this, where it shows how many new jobs are coming to the region. Between 1,500 and 2,000 new jobs are coming or are available now. This is based on conversations that we've had with all your employers in the community. As far as new residents captured by Sheboygan, 50 and 90% are listed here. We did not take the jobs into account one for one, but we factored that into the new resident percentage at the percentages shown. Natural household growth, that's back on that chart, with population growth and the chart of the units that are built. And then the pent-up demand since 1990. Recommended vacancy in a healthy market is between 5 and 10%. That includes owner-occupied and rental units. So your demand for new housing is between 2,800 and 5,200 units. That sounds like a lot, because you have opportunity here. You have employment, you have jobs, and you have a shortage of housing. Right after we published this study, Kurt Paulson, who's a professor in the Planning and Urban Development Department at the University of Madison, Wisconsin, called out our study as being one that recognized and acknowledged the employment growth. Most housing studies don't acknowledge employment growth. And he called us out on LinkedIn with a post, and so that was very, very gratifying to be recognized by someone who teaches in this industry. We created then the demand forecast for rental and owner-occupied housing. As shown here, we wanted to give options and put a balance to how much should be affordable and how much should be market rate in each of the size categories: studio, 1-bedroom, 2-bedroom, 3-bedroom, and then as an owner-occupied, including 4-bedroom homes, so that this really dials in the demand. And that is the end of my presentation.
Okay. Good evening, everyone. My name is Brian Dowden. I'm the Executive Director of the Sheboygan County Economic Development Corporation. I moved here in October of 2020. Prior to that, I was in Eau Claire County for a decade, and then in Portage County or Stevens Point area for a decade in similar roles. But Sheboygan County, and Kristen already said this, is a very unique market, and really is a very attractive county for overall development and making things happen. One of our logos, on our logo, we just simply say we do more here in Sheboygan County, and that is truly the case. When I arrived here, the corporation had never really done a strategic direction. I don't call it a strategic plan because you always have to pivot based on market conditions. So this slide was developed back in 2020. I just wanted to highlight, I'm kind of giving you the how we got to this point. But back in 2020, my board of directors, 39 leaders throughout the county, really was looking at what do we have as barriers to growth? How do we make sure that we can continue to grow our economy, our companies, and our communities effectively? And so when we looked at the building permits over the history of from 1990 all the way through 2019, through the Great Recession, we really lost around 200 building permits of single-family homes every single year. That's really tied not to the economy locally, but to the national environment that we were in. That is because lenders shrunk their ability to actually build homes. You had to have a whole different level of ability to finance. Local builders, we lost a lot of local builders that were smaller just because the risk factor and the ability to get financing wasn't there. So the housing industry as a whole shrunk in this market. So that's what we started focusing in, and this before my time, on apartments and trying to get apartments developed, but also when we started looking at this during our strategic direction and future conversations, we had CEOs basically say, Brian, we can't recruit people to apartments. We need yards. We need places for people to live and raise families. So during that time, we adopted that we were going to start working on housing as a overall addressing economic barriers to growth for our companies and our communities. This is actually some multiple listing services from June of 2021, and it's actually from a home builder that is from outside the market that we were talking to, having an interest in this market. And later on, you'll hear their name and the story, but I'm just going to let you know that days of inventory back in June of 2021, during the peak of COVID, we had 10 days of inventory. Very definitely, COVID had some impacts to that. But even today, our average time on market is 33 days, which is 20 days below the national average. This is a seller's market. Sheboygan County, if you have a house, you have a great asset, and because there just isn't inventory and there's going to be more buyers than inventory available. So what we have jobs, cost of living, lifestyle, and schools. What we don't have, though, is supply of entry-level homes, and I want to stress entry-level homes and supply affordable homes. The reason I mention entry-level homes is because that's where, when we look at the manufacturing sector that is growing very rapidly, our board really focused in on the private sector without major assistance cannot build entry-level homes that are affordable for those people working on production lines and plant floors throughout the county. But that is 30% of our labor market. So we have to be conscious of how do we make sure that entry-level homes and inventory is available for everybody to live in an environment they seek. Again, we're a unique marketplace. Maybe you don't realize that, but we have family-held corporations for generations that are global in reach, but also actively engaged every single day in their business. That, on the size and scale that we have in Sheboygan County, you're a unicorn in the national economy. When we looked at large employers on a national level, we were the third, and back in 2020 when I was doing this analysis, we were ranked third or fifth in large employers per the size of a county. We have difficulty recruiting into the market because no one can imagine a county of 120,000 people has that brand in the marketplace. If you're coming to a community of 120,000, you're worried about, hey, if it doesn't work here, where am I going to go? But we have the corporate jobs. We just have to start really rebranding and repositioning ourselves effectively. Our food and beverage corporate headquarters, but then you look at all the other aspects. But again, even the ones that are food processors from outside the area without local corporate headquarters, family held. So we are very fortunate to not be reliant on corporations that are not tied to family values. When I first arrived, we had a slide that said 3,000. I'm reducing it down just because we have been growing at a pace. However, I will just let you know that's currently available or not filled. But we have, and I'm doing it, my board meets tomorrow. We're under 7 NDAs right now for corporate expansions. Investments are going to be over $300 to $400 million over the next several years. You're talking at least, at least over 1,000 to 1,500 new jobs with some of those projects. and that's conservative. So again, when we start looking at the major investments that these families and or new corporations are coming into the marketplace, we have to look at how we make things happen and remove barriers to growth. So this is a slide just showing how fast our employment growth is, while we're only averaging building another 100 to 150 homes per year. So I think that's slide right there. Our companies outpace the ability to build homes in their growth. So if you don't know, we've, because of all of the demand from those corporations, 4 of them stepped forward to create the Forward Fund, and now we are building subdivisions of entry-level homes, trying to hit the price point that is affordable for the working population across the county. That took 6 months to get $8 million raised so that we can start building entry-level homes that are really not hit by the private sector traditionally. From a marketing standpoint, I just want to show you what we do. Just because I got an email today that we were on next door. So just to give you a sense, we have books like the 2023 Developer's Guide. I'm going to start telling you about the development process and how it goes. My employee that responded to whoever came into the office was a week on the job, so I just want to say sorry that you didn't get good information, but a week on the job, you didn't know all the facts and figures. So every single year, we host an annual Developer Summit. The books I have here are from 2023, but we have another book for 2024. That is tied to our target audience. CAR W is all the real estate brokers, okay? Primarily Milwaukee, but that goes into Madison and other markets. NAIOP, that is the developers or real estate investors. Typically, they work with the realtors or brokers to find sites, because once they find a site, then they start saying, how do I make the economics work? Working with development agreements and things of that nature. We also work with WIDA, which is for housing tax credits, looking at who's done projects in different markets across the state that would be comparable to Sheboygan, so that we can introduce new companies or new developers into the market when appropriate. And of course, we are fiercely local. We will try to do every deal as much as possible locally, so we will always invite local developers, builders, and investors. Local lenders, we have a banking cohort of every bank in the county, and then also entities with working relationships. I've worked across the state, city staff has worked in different areas, so we continue to add to that based on relationships. Okay, so that's kind of the Developer Summit. In 2024, we had 70 people participate. We had it scheduled earlier in the October. We canceled it and moved it back to October 29th, just because city staff, there was a transition, and we wanted to make sure the new staff person was able to participate. This is the type of things that you would see in the book, and I brought this specific site up because this has been marketed since arriving. You will see if it's in a TIF district, what the price is, what the size is, what's the traffic count, where sewer and water is located, where storm sewer is located. All those things that a developer will need to know in order to do a site plan. Our job is to de-risk the opportunity so that a developer is saying, hey, I am interested in that parcel. I'm interested in that community. By the time we get a developer or realtor in this market, they've already sold themselves on investing in the county. That's typically the case. Then now is, what is the site that works best for my opportunity to grow in Sheboygan County. So related to this particular project, as I think everyone in the neighborhood knows, this is owned by Aurora, and they had a brokerage relationship with Borky out of Milwaukee. I think they were doing quarterly updates, I believe, to the neighborhood association, and they were working on trying to get a single-family housing developer coming into the marketplace. Casey and I went down to meet with them in January of '24, trying to, on multiple projects, but specifically saying, hey, where are things at on the neighborhood? They're worried about what's going on in the neighborhood and what it's looking like, what's your progress, things of that nature. During that meeting, we found out that they had no local developers or builders interested or have submitted any information. They had one person that worked for a contractor in the community that lived in the neighborhood that had inquired, but did not come forward with a formal proposal. They had 3 brokers that had builders that were showing interest in the property, and 1 multifamily developer as well. However, none of them put together a proposal on the economics and saying, we're willing to write some due diligence checks to come up with a site plan and figure out what is most appropriate for that site. Knowing how important that site is to the neighborhood, the city was very cautious and wanting to make sure that they were delivering on your expectations. And I just want to commend that process. From that January meeting, on the way down, we happened to meet with Newman Homes, which is probably the 3rd or 4th largest contractor in the state. They very definitely have been on our relationship conversation since 2021 when I arrived to town. Just because we need more capacity for homes, single-family home building. During that session, it was, hey, we're interested in the Sheboygan market, but the economics of today just don't work. Long story short, at the end of that meeting, they said, well, at least we will start the conversation and do market research. By April of that year, 2024, they came back and said, we are interested in Sheboygan County and investing in Sheboygan County. We would like to review sites throughout the county for opportunities. That's when in May they came up, their leadership, and met with city staff in multiple communities. And then we put together what's an action plan for you as a developer. And their first comment was, we want a certain size, a parcel, things of that nature. But long story short, they said, but we want to get something started right away. And that's when this site, which was in the book that they had seen, was an opportunity, and they said, what's going on with this site? So this site originally was Newman Homes' first project location. Proposal for 25 homes rather than 21, which is, I think, the current estimate. Price point's about the same, so you would have had higher density than what is currently being forwarded from a development agreement. Long story short, the city's development agreement was too stringent, at least one specific term that they asked to have removed, which the city and the city attorney would not, squash the deal. And that is August timeframe from a opportunity, and that's when the city determined that we needed to find an opportunity for pivoting, and that's how the next developer moved forward. But I want to stress that this project, and the reason why the city engaged in this process, was because of Newman Homes and bringing them into the county as a new developer, a reputable builder in the marketplace. on this particular site. And just to give you a sense of other countywide projects, Vanguard Group out of Milwaukee, they're coming into Plymouth with 156 apartments. Then you have General Capital in Northtown and Elkhart. I think my own closing comment would be is, if you look at the percentage of TIF incentives being provided in the city, quite honestly, it's not competitive to other communities in the county. It's below what other communities are providing. So for preservation of the public dollar, you are very fortunate to have the city staff and the legal team that you're working toward this type of development agreement. Thank you.
Hello, hello, can everyone hear me? I just want to make sure that the thunder doesn't drown me out. With that being said, my name is Taylor Zeinert. I am the new Director of Planning and Development. I think Kristen and Brian did a great job of painting why Sheboygan is fantastic. With that being said, I am excited to join this team and I'm excited to be here. You guys have lots of great things going on and I'm excited to help facilitate some of it. The first half of the presentations today kind of talked about the basics, talked about what is a development agreement, what is a TIF. The latter half, you heard a lot about the housing study, what things are going on. This presentation is going to focus on merging those two as one. So just talking about the basic steps, especially at City Hall when it comes to developers and things like that. First thing, a developer reaches out to us. Brian had previously touched on that, where Sheboygan has a lot of great things going on. So what that means is that a developer will reach out to either the city administrator's office, the mayor's office, or sometimes the Office of Planning and Development. They'll go through and they'll say what they're being, or what they will share what they are proposing, and we'll talk out those next steps, which is the location, the size, the end goal, the timeline. Those are all things that were previously touched on, and those are things that the developer would like to discuss, and that's something that we want to know as well. Next part is that the city staff discuss those next steps. So the site plan, the partners of the project, and then any financial asks. So site plan for the project, that's something that the planning development team really hones in on to make sure that it meets our zoning requirements and things of that nature. Partners for the project, so are they working with nonprofits? Are they working with private investors? Things of that nature. And then additionally, do they have financial asks? It's really storming out there. Okay. The developer requests TIF assistance. This is something that happens sometimes, but doesn't always happen. When a developer does ask for TIF incentives, we ask them for tons of information. That's something that Kayla and Brian touched on. Those range from pro formas to list of investors, timelines, and phases. The reason why we ask those is, one, to make sure that we are making a good investment. We want to make sure that we are using the tax dollar properly. And then two, those clawbacks and things that Brian had talked about, we want to make sure that those are asserted. If not, like how the other Brian shared, like the Newman development, then we just won't move forward because we have standards and we have expectations of them. The next step is that the developer has to share that gap in financing. Kayla had talked about that but-for assessment. But for this financing, the project would not happen. So staff works with Ellers to do that assessment, just like how Kayla had talked about, and they do that internal review. They ask all of those hard questions. The next one is that we always ask for feedback. Specifically, in this next slide here, we'll outline that we have a Thursday meeting. That meeting happens each Thursday at 10 a.m. where we have all of the department heads and people that come to one meeting. That covers building inspectors, the fire department, the police department, the transit department, people that you see listed here, to talk just to talk about the project, to make sure that it's feasible, so that if this project moves forward, what does that look like for roads? What does that look like for our first responders, inspectors? How often do they have to go out there? Things of that nature. Next step is that the agreement is brought before the city council, and the city council, we see them here tonight. They can ask those questions and they can, vet those. That's just a basic overview. I wanted to really walk us through what it takes to merge these two groups together. Thank you.
I'll open it up to committee of the whole first, to the council. I have only one question, and that is for Alder Bellinger. Seeing as this is his district and it would affect his taxpayers more than anybody else in the city, I was just wondering if you feel comfortable with the proposed TID 25 that is coming next week.
Thank you, Chairman. I do feel comfortable with it. I have been a resident of the Memorial neighborhood for 30-plus years. I was on the council when Aurora was looking at moving to the Field of Dreams, subsequently went to Kohler, and I was part of that whole process. So I've been involved with this from the very onset and the very beginning, and I'm excited to see it through to completion. The neighbors that I deal with in the Memorial Neighborhood Association are very passionate about having single-family homes. I think the city has done a fantastic job. I commend the city staff, those that presented tonight. Thank you for being here and doing that. Our fantastic attorney who is here that is looking to mitigate any type of city exposure and cost to the taxpayers. I commend him for doing that and protecting the city investment. So looking at everything that has gone through with this whole thing, I think the TIF or TID is a fantastic tool to use for this project. It is extremely small and minor in the big scope of things when you look at some of the other TIFs or TIDs within the city or in a state as far as the size and scope of it. What I would like to do is ask city staff, there is a sanitary sewer project that is part of this, and I would like to know if the TID is approved or not approved, would this sanitary sewer project continue? And if it is approved or not approved, who pays for that sanitary sewer project? And if you could just explain a little bit more of the scope of the project so the public is aware that it's not just laterals that are being hooked up into an existing sanitary sewer. So if I could just get that addressed. But again, I fully support this, and I think the work that has been done has been fantastic, and I appreciate everybody, being present and being here tonight. So thank you.
I'm Kevin. I'm the city engineer. I'll try and answer John's question. The sewer line John is talking about is on 6th Street. It's a 100-year-old clay pipe. It's in okay condition right now. If we connect a bunch of laterals to it, it probably will affect its integrity, and we would prefer to replace it rather than dealing with it later when it's going to fail or could fail. If we don't do any work right now, the pipe is okay. It's not high on our radar of pipes to replace or line. As far as the scope of the project, we'd be fixing bad concrete panels, bad sidewalk, adding ADA accessible crosswalks. The gas company is going in, actually starting in a couple weeks, doing some updates. The water utility is going to be doing some work in there. Lead water replacements being completed by the water utility. And then a new driving surface when we're all done and complete. Did that answer your questions, John?
If the TIF is approved, this will go on if the TIF is approved, and as I understand it, if it's not approved, it's still going on. It's going to happen either way. So who pays for it if the TIF is approved, or if it's not approved? Who ends up paying for this then?
The lead service replacement's going to go on, but that'll be dealt with through the water utility. We will not be looking at doing the road work this year or in the near future. It's a project that hadn't been scoped before. The sanitary sewer doesn't need to be replaced at this time, so that's something we're not going to go ahead and do unless the project is approved.
And then the developer would end up paying for it, correct?
Yes, while they'd have to make the connections, and then that pipe would be, the integrity of that pipe would be affected. We'd have to watch it more closely, maybe replace it in the future.
Okay, thank you.
I just wanted to kind of explain why, I'm such a huge supporter of TID. That's a perfect example of being able to use, again, that increment value that's created by the project to fund that, as opposed to it coming out of tax dollars, okay? Out of, either additional taxes or it being diverted from other funds that otherwise would have been paid out of just the normal taxes. That would have been, in my example, that $5,000 of taxes coming from the field, as opposed to that $95,000 of increment generated each year. That increment is used to pay for those project costs that are approved project costs by the project plan, which would be the TID 25 project plan. And so that's, again, an example. Each year the developer's making those tax payments, those dollars, that may be part of the priority project cost that is getting used to pay those costs for those projects, as opposed to it not being paid by the developer and just paid by the community as a whole without the TID. Does that answer your question?
All right. Any other questions or comments from alders? Alder Close.
Thank you again for the presentations. Earlier it was mentioned about the cost flow forecasting and things that were required of the developers ahead of the TIF creation and during the development process. I wondered if anybody could go into more detail about what kind of financial reporting requirements were on the developers or anybody involved with the project over the life of the TIF. Like what would be involved in the financial reporting cadence, things like that.
Sure. So the developer made a formal request for TIF assistance to the city, which included a dollar amount of increment, and then also an understanding of what the obligations of the developer would be for public infrastructure. In this situation, we looked at what the increment generated, what could be supported from an assistance request, and then really drilled this down with Attorney Winters to understand what are the public infrastructure costs, because like he said, those are those priority projects. And so after that annually available increment, it was determined that the financing gap between what the developer could finance on their own with traditional financing investors and what was needed to get the deal done essentially was $1.6 million. Over 20 years, they will be receiving roughly $52,000 a year as an annual incentive. But the majority of the incentive is the property and the public infrastructure. And that really is going to be financed through general obligation debt that will be repaid from the increment before anything is available to the developer.
Okay. Could you also speak to what the developer is required to report forward to the city or the state of Wisconsin with regard to how they're developing the program? Do they need to provide any financial reports, any statements? Is there a regular cadence of reports that need to be provided to showcase how well they're doing, anything like that?
So that's really where the key parts of that development agreement come in, is that marries the developer to that minimum value regardless of what happens. It's important to note that when you're looking at this cash flow, you start to see tax increment in 2027 coming in, even though construction hypothetically could start in '25, there's a 2-year delay between construction and tax generation and revenue, and that's based off of any development in the state. So construction within 2025 is valued as of 1/1/26, which is revenue tax collection of 1/1/27. And so getting an understanding of what's that immediate financing gap and what are those liabilities, that's kind of the paperwork we need from the developer is what's the build out schedule? What is the first phase of homes? What are those values? What happens if those values come in low? That's that shortfall payment. After these houses are built and developed, it's really the development agreement that is the steady and fast. There's no reporting requirements. The city has obligations for reporting from an audit perspective and from an annual report. All TIF districts in the state of Wisconsin are required to make an annual report to the Joint Review Board on the taxing or the cash flow status of it. But from the developer's perspective, after the development's complete, there's nothing that is required from them outside of the provisions of the development agreement.
Great, thank you.
All right, Alder Bors.
Thank you, Mr. Chair.
Can I add one thing to that? So through our development agreements, we actually put additional requirements on. So every project's a little different, and that's why we have a standard template that we use through Attorney Winters for development agreements. So the incentives do a couple different things. So one is the but-for test, but as a part of that, like with this project particularly, we're putting a mandate that they have to have an aesthetic that matches the neighborhood. We're trying to get a price point of the houses to that match that what we have is an established need for kind of that affordable for our existing workforce housing, things like that, not necessarily subsidized housing, but trying to use that incentive to buy that down. We've done some projects like the Jacob Hall, which is now the Lidkey Apartments. In that particular project, not only did we go for the aesthetics, but then we also, we have them committed for the next 26, 27 years to where they have to report back to our planning department every year and certify what their annual rental rates are to ensure that they're below the county affordability. So they're locked in at that for the entirety of the TIF. So they get an incentive that helps to make up the lost revenue that they would have had on their rental rates, things like that. And they don't get that incentive now. That incentive is paid annually over a 15 to 20 year period. So like in this one, we're talking a $1.6 million incentive, that's incrementally paid out over a 15-year, 20-year period after all of our costs are recouped. So the value of that money is substantially less. And traditionally what we're seeing now and why we have a little bit higher than what the city traditionally did is because of the interest rate market that we're working with right now. 3 years ago, you were dealing with a 3 to 5% interest rate market. Now we're seeing 10, 12% on some of these projects. So they're just not viable to keep that price point down where it's affordable.
I know that a lot of the concerns from citizens that have been sent to all of us, I think, on the council are around the density that's being proposed for that or by that developer for the property and the number of homes that are included. And while the potential approval of the TID district kind of opens the door, if you will, for the development, the agreement itself obviously has not yet been approved and could still be modified potentially to include more density and or to ensure, as you just mentioned, that homes are keeping with the style of the surrounding neighborhoods, things of that nature. So can you just validate, I guess, that that's accurate and that changes could still be made from a density perspective and things of that nature?
Yeah, I can start and then Attorney Winters can. So yes, there's two distinctly different processes here. So a lot of misconception has been kind of pushed around approving the project plan, approving the TID, which is the next step in this process by council, is only approving a plan. There's not no project is approved, nothing is actually, as Kayla pointed out, the project plan is what we believe it's going to be, and it's what we believe it's going to be for the next 27 years. But not a limit on the number of amendments that can take place. It's understood that these plans will change. So there's no debt taken out. There's no incentive that's being given. That is all spelled out in the development agreement. So development agreement would be the next step in that process. And the one thing that, going back to, we have developers that walk away because our is to protect the community and protect our investment, and it's a partnership, a long-term partnership. Require that every developer must go through the entire process, get any favorable treatment just because they have a development agreement, and at any point they fail to meet the requirements of the development agreement is null and void.
Yeah, and I'll just highlight one part, because in case you hit on this, but it's really two steps, and the creation of the TID sort of sets the table and the framework and the opportunity to take advantage of the tax increment generation, okay? Without the TID, there's no incentive. There's no increment, okay? And so you set the TID up to then determine what projects you want within that TID. And so I think the point you were getting at was, if the specific project is of issue, that is not what's being approved by the creation of the TID. The creation of the TID is just setting the framework for development to happen within the boundary of the TID. Okay, and what the proposed plans are, or what the proposed thought is going to be, how the property is going to be developed. Then you get to the development agreement stage once the TID's created, that sets forth the agreement between the city and the developer as to the actual project that will go on a specific parcel or parcels in the TID.
Alrighty, thank you. Alders, just for transparency, we're going to go into attendee participation. So the way this is going to work is Clerk DeBruin will say your name, and Fire Chief will come to you. Please be nice to him. He is a Bears fan. And you'll get 2 minutes. I'll give you a 30-second warning if you're going long, and then to wrap it up. And we'll have whoever you're asking the question to answer your question, and you get one follow-up question after that. So, Clerk DeBruin.
Thank you, Chair. The first person that signed up is Lisa S. If you raise your hand, Fire Chief can find you. Thank you.
Thank you. I'm Lisa Salgado, 931 North 4th Street. I'm the founder of a citizens group called Sheboygan First, which is a nonpartisan group that focuses on local issues and government accountability. If you're going to take out TIDs in our names, then citizens need a voice at the table. City officials often say that TIDs don't affect our property taxes. But based on Wisconsin tax levy laws and the City of Sheboygan's own annual assessment summary, it appears that's not accurate. From 2025 to 2030, the city can legally increase its property tax levy by at least 20.2% because of nearly $1 billion in TID subsidized construction planned under TID districts 21 through 25. These increases are allowed under state statute because this construction, even though it generates no new property tax revenue for the city, county, or school district until the TID closes, expands the tax base used to calculate levy limits. So my question is this: are you aware that nearly $1 billion in TID-funded development enables a minimum 20.2% increase in the city's property tax levy by 2030, even though none of that new tax revenue will support general city services or schools until after 2048?
Who is that question directed to?
I would say anybody that can answer it. If council can answer the tax levy.
Does anybody want to take it? Otherwise, I can. I feel personally comfortable. I believe our city staff is very well educated on this, and they know what they're doing, past staff and present staff. As you can see, we have a handout that everybody's free to take home, is by the agenda, that explains the history of TIDs in Sheboygan. And we've had TIDs since 1988, and as far as I can tell from reading this, all of them have been successful and increased the worth of the increment. So while that is a big number and it's supposed to sound scary, I personally know that it will create that much value for our community moving forward. Would anybody else like to add? No? All right.
I just have a follow-up question.
Yep.
Because the more new buildings that go up, the more the city is allowed to tax.
I'm going to refer that one to Ehlers.
That's on a net new construction basis. So the levy limits in Wisconsin, without getting down in the weeds, one of the only allowable increases to the municipality's levy limit, meaning how much taxes can be levied against properties in the city, is on a net new construction basis. So the value of property removed plus added, that includes TID property. But that is a council decision on an annual basis whether to utilize that full net new construction number in the setting of the levy. And so, yes, we can lump it all together and kind of put the baby with the bathwater, but those are annual decisions made by the council as to what they will utilize from that net new construction in the setting of the annual levy.
Sorry. No. No. You get one follow-up. The rules are you get one follow-up, and the next person that can ask a question.
Tina K.
At 419 Niagara. My question is, can the council explain why the city is committing to pay over 40% of an $8 million project by spending more than $3.2 million when the city of Sheboygan's own 2021 TID policy states that tax increment financing should not exceed 15% of the project's area total assessed value? This level of public spending appears to directly contradict the adopted policy, and residents deserve to understand why the standard is not being followed in this case.
I'm going to direct that to
Council.
City Administrator Bradley because he is hired by the council.
Yes, so as I stated earlier, those policies were written in a different era of interest rates. And we're seeing that in every project. The requests are substantially higher and they're demonstrating need at a higher level just because of the interest rates. So the statement of $3 plus million, that is not incentive that the developer is recognizing. As Engineer Jump explained, those are costs that would be citizen costs if this property were to develop, because the new laterals coming in is going to weaken the integrity of the existing sewer system, so we'll have to replace that. So those incentives that are part of this project would happen as a citizen cost, or they would happen as a TID cost if we didn't have a TID there. So those are not a direct benefit to the developer, but the incentive that would go back to the developer is helping to defray the cost in this interest rate environment. So as the interest rates go down, then we will reevaluate and address that moving forward.
Shouldn't we write a new policy then, in the meantime?
Yes, and that's, now that we have Taylor on board, we'll be updating our policies and things like that.
The next person is Lisa B.
Thank you, everyone, for the opportunity. I just have a quick question for the council. Could you help me understand why open record requests from multiple Sheboygan residents have gone unanswered or been significantly delayed despite the Freedom of Information Act? Looking it up, it looks like you should have 21 days to respond, unless it falls under 9 categories, and in these cases it does not fall under those 9 exemptions. Some of the requests go back to March 17th and involve multiple people. Can you help me with that?
So that's not TID related, but I'll refer that to Attorney Majerus because she and her department handles that.
I'm not sure exactly which request you're referring to. I can tell you that the city works through open records requests based on the order that they're received and the time that it'll take to locate the records, review them for appropriateness of release, meaning we want to make sure that we're not releasing any confidential information or proprietary information. So we first have to assemble those records, review them, make any necessary redactions, or evaluate the decision to make redactions. Then we need to release them, and we work through that in the order with which those requests are received. If you would like to send me an email outside of this meeting as a follow-up to any requests that you're waiting for, I'd be happy to reconnect with you that way.
Okay. In one case, there was a mention that after 14 days that they would send an explanation as to why they could not fulfill it. That was not completed. That also goes through your office then?
I have no practice of sending that sort of message, so without knowing the specifics about your request, I'd have a hard time answering that. But if we could talk offline, if you would give my office a call, we can work through that together.
Thank you very much.
Mary D.
Hi, the question I have is about open bidding, and can the council explain where the open bidding process was for the memorial site development and where we can access that information? City Administrator Casey Bradley claimed the current unnamed developer was the only one interested. However, Wausau Homes contacted him recently with interest. Posthuma Homes expressed interest at last year's developer summit, but was told the developer agreement was already in place, which we believe is not. And why wasn't this project opened up to competitive bidding? And why is the city pushing a false narrative to justify bypassing standard procedures?
So I would like to remind...
And who, I'm sorry,
yep.
And who is the developer for the Memorial Hospital property?
All right, so I would like to remind everybody here that the Aurora site was owned by Aurora and does not need to disclose how they tried to develop it or market it. So that might be why we are having that issue. Otherwise, I would recommend Administrator Bradley explain the process and why there's reasons why we can't share certain things.
Yeah, and please include the fact that we understand that the city bought the Aurora Hospital property.
Yep. So as Brian explained, so this has been in the development book and marketed through the various groups for 3 years, 4 years. So it's been every year. It's been at our development summit. Developers have the opportunity to come in and propose on that project. None had come through. There was actually a group, Borky, was hired by Aurora, and they marketed it for 2 or 3 years. So they were actively trying to seek out different developers. As Brian said in his presentation, they had 3 proposed projects. None of them came through, and none of them proposed. So the email that Mr. Postuma sent, he did talk to us at the developer summit. At the same time, Mr. Postuma was working with us on another project that he is still working on And he also, I believe, was awarded the contract in Sheboygan Falls. So we're already working with him on a number of other projects. And then the Wausau Homes individual did come to a council meeting, and they had no interest in funding a project. Someone told them that there was an expectation that they were being given away, and then they'd have to put up a commitment. And we talked about the requirements of our development agreements, and they said they were not interested at that point.
So who is the developer?
Thank you, Chairman, and thank you, City Administrator. I would just like to make everybody aware that as the alderman for this district, I've been in extremely close contact with the City Administrator on this project. He's kept me aware of all sorts of different developments going on with that project. You know, when Aurora, before the city purchased it, so on and so forth, with potential developers, the TIF district, TID district, everything. There is no deception of the public or alternative narrative that, that the city is trying to pull a fast one on this. This has all been very well communicated, and we can share what we can when it becomes public, when there is a development agreement. So, there is not a development agreement right now. It hasn't been presented to council. We haven't seen anything. It's all hypothetical at this point. We first need to get the TIF or the TID passed, and then we can move forward with that. But I would just like to let everybody know that there is nothing going on under the table, in, dark rooms, anything like that. Everything has been very above board, by the book, and I appreciate that, and I frankly demand that as an alderman of city staff, and they have done more than comply with it.
You're allowed to follow up.
Okay, so we do believe that it is the same developer that is being addressing the Gartman property, and they've changed their name to North 6th 7th LLC, which would make sense since the property is between 6th Street and 7th Street. So I guess, and that was a LLC that was developed on April 10th, 2025. This is all about trust and transparency, and we feel that we are being fooled.
I don't know anything about that. I will give that to Attorney Winters.
I'll just speak very generally about development, and hopefully this addresses your concern. Very typically speaking, developers will create special purpose entities, as they're called, or a specific LLC or corporation for each project that they have, and they'll create a unique name for that project. Okay, and that's why, as part of our job with the development agreement, we understand who owns that LLC. We require to know who's the members of that LLC, other than South 6th, West, North, whatever it could be, the name that they create. And so our goal is to really understand who we're dealing with, but there's nothing nefarious about a very specific name, because that entity is created just for that project. I can't think of a development deal that I've done in the 18 years that I've been doing this where there's a developer that's just taking on all of that risk, because if one project goes wrong and it's connected to 5 other projects, it can trip up all those projects. So they create one development, they do create one entity for that project, and that is that name.
So again, back to the process. If some developers choose that once they get so far into a development agreement process that they'll set up an LLC, I don't know what you're referring to because I'm not familiar with who the company is. I know I got some emails that were sent, but it still doesn't mean that there's a development agreement. Ultimately, it is council's decision. So as Brian alluded to earlier, we're about basically at the same process we got with Newman Homes when Newman Homes decided to back out. So it's a different developer. If they decide to make that decision and create an LLC and incur those expenses, there is not a development agreement there. And even once the development agreement is approved, that still doesn't mean there's an approved project, because they have to go through staff review of their project plan. They have to go through the plan commission. Every project that we've had so far, the developers have made changes to their projects based on the feedback from the community. So it's a long process before we ever incur any expenses or any incentives are ever paid. So I know people want to make an assumption that a development is done deal. It's a long ways, and even after a development agreement is signed and approved, the developer could walk away for a variety of reasons, or as Attorney Winters pointed out, there's a variety of reasons we can walk away from the project. And one of them is, if Plan Commission or Council decides they want a different density, they want a different layout, they don't like the product type that they're proposing, and they're not willing to fulfill that, there's no deal. So no money's been incurred, nothing, but they're looking to spend a lot of money in this process of design. So they want that comfort that if they go through all of this, that's going to be there. So it's just the very start of a project and nothing's been incurred.
The next person is Victoria W.
Hello, my name is Victoria Weezy. My address is 6279 South 18th Street, Sheboygan, Wisconsin. I own property in Sheboygan as well. And the question that I have, and in respect to time and detail, I copied the questions that I have for you to look at and to respond. So the question is, can the City Council explain why the cost of TID 25 was allowed to change during the approval process without going back to the City Plan Commission or the Joint Review Board for reapproval? Also, what are the proper procedures for modifying a TID proposal after submission, and were they followed in this case? Also, can Ehlers clarify why the TID 25 report omits the individual increment values of existing TIDs, especially when the TID 23 included that level of detail? The report relies on January 1, 2024 figures, yet 4 major TIDs totaling over $347 million, including $146 million in developer incentives, were approved on March 4th of 2024. Why are those omitted, and how can the public assess compliance with the 12% equalized value test without that data? Thank you.
Sure. First of all, the only change that was made to the total project cost was to include the portion of the project we are deeming as a non-project cost for the public infrastructure. And that was really as a transparency effort to get an understanding that the total project of that sanitary sewer and project is $1.3 million, of which only $600,000 is being allocated to the TID district. And that was the same as it was before. It was just now adding the column that says less non-project costs of about $750,000. And so I'll take the onus on that I left out the non-project costs because it was really just what we're being allocated to the TID. But in an effort through the review process of staff and Attorney Winters was really erring on the side of transparency to give an understanding the entire project is actually $1.3 million, of which the TID is being allocated $600,000. And that goes back to that kind of projects when we look at what is attributable to the district, what would be liability versus what is being served outside of the district boundaries. As far as the 12% test, I'm going to assume you're talking about the increment of districts 21 through 24, which were created last year. There is no certified increment yet. Remember that it's 24 construction year value as of 1/1/25. Those values are not certified by the Department of Revenue until August 13th. And so the 12% test is taken at the snapshot of when you're creating the project plan. And so there is no certified increment value of those districts, and so therefore they're not included in the 12% test. Only the increment of the existing tax districts that are certified, or TIF districts that are certified, are included in the 12% test. The TID 21 amendment, I think that you referred to, overlaid all the parcels that the overlay, the boundary amendment were already in TID 17, so therefore that's also not included because they're already included within a district. Does that answer your question?
I think so. Thank you.
Would you like a follow-up question?
Not that I can think of. Thank you.
Thank you.
The next person, Wyatt B.
Yeah, I just had a quick question. So I reached out to a council person. They told me that the sanitary or sewer that you spoke about earlier would be paid out of the incentive that the city gives to the developer. Is that true information? The incentive that the city pays to the developer, they're going to take and swallow the cost to pay for the sanitary and sewer. Is that correct?
I think it was, at least from what my understanding was, is that was for the private side, and the public side would be financed through the general obligation debt because laterals go onto private property, just the main, but that's just my understanding of that project.
So the way it will work is there may be city costs that are incurred. That will be what we call the priority project costs. Those come out before that available tax increment is made available to the developer. Okay, so whatever the city's obligation is comes out first, and that's coming out of developer tax payments. Okay, then there's a percentage of the available tax increment that goes back to the developer to use as reimbursement for their costs, whatever that may be, or however they see fit. But to, I think, answer your question, the portions of the costs that are incurred by the city, that's what the priority project costs will help pay for, again, from the developer tax payments. Whatever the developer does with its increment that it gets back through the agreement and the development agreement, they choose to use that however they will and document that in the records for reimbursement or whatever else. So I can't answer it as to how the developer will use it or what they'll use it for, but for the city, again, they'll take that increment and apply that to the costs, again, before that breakdown to the developer. Does that answer your question? Okay.
Yeah. So then who at City Hall is telling our council people the wrong information? The council person didn't take that out of a hat, that the developer would pay that out of the incentive. So I'm just trying to see where the council people are getting this information from, because it must be someone at City Hall.
Wyatt, I'll answer that question. It was most likely me. We've had multiple conversations. If I communicated anything incorrectly, I apologize for that. I am not getting any misinformation from, city staff or I may have misunderstood your question. I'd have to go back and look and see what kind of context, how it was asked, and what my exact answer was. But I'm not someone who passes along misinformation. I'm an alderman who questions a lot of things, whether it be with city staff. I have regular conversations with the city administrator, ask him all sorts of different questions. And if I passed on anything incorrectly, I apologize for that.
And this is a very complex and, obviously we have a lot of folks that come help walk through this process to make sure it's all done right. One post, we did have some conversations, was a misunderstanding that when we bid out the road project that there were laterals in there. So folks were under the assumption that we were doing laterals onto private property, and we don't do that. But there are laterals that are still in the public right-of-way. So some of that cost is ours, some of that is theirs. So parsing that out through these contracts. Like Kevin pointed out, there's going to be part of the Clean Water Fund is going to be funding the portion in the right-of-way because that is federal and state money to help replace these lead service lines. Earlier this year, I think January, February, council passed a resolution where we actually took a bond out, and the state gave us, if Caitlin's not here, I think it was like $2 to $3 million to match the community's commitment, and that money will be used as grants to fund the portion basically from the right-of-way to a person's house. So under federal law, when you replace a water line, you're not allowed to hook a lead service back up. So we're not able to pay for those things on private property, but through these other programs, we're able to help defray that cost. So it does get kind of murky when you get into these issues, but basically if it's in the public right-of-way, that's something that we would work with. And depending on what type of utility it is, if it's water or sewer, we can fund it one way. If it's roads, we can fund it another way. But we don't do anything that's for the private party.
The next person is Melody Kay. She went home. Thank you. Brian Kay.
Hi, my question is kind of going to what Susie was saying before about the density. From the city's TIF goals, one of the goals is to promote infill development that can achieve the highest and best possible use of land. From what I was hearing, it sounded like these 21 homes, we're trying to target like a certain price point with them, with the TIF incentives. To my understanding, once a TIF closes, we can use, like for a year, that extra increment towards other like affordable housing throughout the city. So I'm wondering why are we not like just allowing the developer to do what the market can support, maximize our increment, and then sort of go for the affordable housing once that TIF is closed? Why are we not maximizing the increment, getting more housing built so more people can get housed, and then kind of doing that affordable housing at the end?
Do you want to talk about the need? The need?
Sure, yeah. That's what I was thinking. I think that to wait how many years to get affordable housing built until you have affordable housing funds is not meeting the need that exists today. And so many of those occupations that I shared in that big long list are getting housing that they can afford. So I think in response to the demand, if there's a developer that's interested in building that to meet that demand, that should be met as soon as possible. We interviewed, I'm also consulting with the city right now for their community development block grant, and we interviewed every public service provider that had received federal dollars through the city, and the need for affordable housing is really serious. So it's a dramatic need, and if you have the opportunity to build those houses now, I would say do that. You're still going to be collecting increment on those that will then still add to that total later so that you can use that fund to build even more affordable housing.
Can I ask a follow-up? Yeah, so I think in your study, you had mentioned the missing middle housing, where it's like things in between single family, which is the most expensive to build, and then apartments, which are like the most like units per dollar, whatever. Like why, I'm still not quite understanding why we can't maximize increment on this development and then pursue other TIF dollars or other TIF districts where we can maybe do that missing middle, where it's not quite apartments but not quite single family. Seems like we're spending a lot on the most expensive housing to be affordable housing rather than, I don't know, maybe more efficient ways to use that tax dollar.
I think you need it all as soon as possible. So there's opportunities to build missing middle homes now. There are opportunities to build affordable homes now. There's opportunity to build market rate homes now. And I think a lot of that all is going on at the same time. So I guess I'm a huge advocate for missing middle housing. I think if you have a site that is appealing to a developer for a product that they see a need for in the market, they're doing their own market studies too, and their bank has to see that there is a demand for that based on not just the market study that the city had done, but the developer is going to highly likely going to have to do their own study too. So the bank is going to make sure there's a market for it. The developer is going to make sure there's a market for it, and they're seeing this need. So I think there's an opportunity to do it all and to collect all the increment that you possibly can. I guess that's all I have to say.
Annette C.
Thank you.
Hi, my name is Annette, and I've lived here 3 or 4 years, not quite 4 years. My question is a little bit more general, kind of regarding the housing study. I would like to know how many vacant homes there are in Sheboygan currently. On my block, there's one that's been vacant for like 10 or more years, and the other one across the street has been vacant for 2. It's a duplex. I noticed there is a lot of affordable housing around Sheboygan that's actually empty. It's not currently occupied, and if it is occupied, it's occupied by Airbnbs. So I want to know why those available housing units aren't being used for the housing of our citizens versus vacationers, and why they're empty most of the year. I would also like to know if there are extra taxes on empty houses in Sheboygan, because if there's not, there really, really should be, because then you can have more money to build affordable housing for our middle class people. I would also like to know, off topic, what we're doing for the unhoused citizens of Sheboygan. There's currently about 50 people who don't have a place to live. They don't have a place to go. The Sheboygan Pay It Forward had to vacate their building, and I don't think the city's doing enough for our unhoused citizens, our low income citizens, our lowest income citizens, and the middle class. You guys want to build $400,000 houses, 21 units. How many are going to be affordable? What's the cost of the lowest house that you're going to build? $200,000, $250,000? Are you kidding me?
30 seconds.
So why are there so many vacant houses? Why aren't you taxing the Airbnbs higher? Why don't you do something about all the vacant housing? And what are we doing about our low and unhoused citizens?
So I can speak as far as the empty homes and Airbnbs. I know that last year we met with Airbnb, and we're working. You'd have to talk to Mayor Sorensen and Alder Decker, since president and he's the mayor. They have been working with Airbnb, and I know that they're trying to come up with a way to create less Airbnbs or fill them if they're empty for more than 6 months at a time. I don't know about that, taxing more for air. I don't know about that, but otherwise I would recommend our city staff for how many vacant homes we have, or how many of those vacant homes might be blighted and might have to be a tear down and rebuild.
I'm sorry, I missed the last part of that question, or that comment. I'm assuming, when we looked at the vacancy rate, it was so low. There will still be a random vacant house here and there, or a house that's not got someone living in it that may not, it might not look like there's someone living in it, but it might not appear vacant on a vacancy rate. Vacant housing is either for sale housing or housing that's available for another person. So we're doing a housing study in Kewaunee County right now, and the city of Algoma has a 12% vacancy rate, and most of those homes are Airbnbs, which is, it's a local issue, but it's not an illegal issue. People can put their house up for Airbnb. That's legal. So it's unfortunate when it could be used for another person. That's their personal right to do that as a private property owner. I mentioned that I'm working with the city's federal dollars for community development block grant right now. Every year the city receives about $910,000 from the federal government in community development block grant money. They can spend 15% of that money on public services. We just closed our application round on May 8th for this coming year's money. And public services like the Salvation Army ask for as much as they possibly can, and we have given them what we can in the past. We also help the Abode, which houses homeless people, and at least 3 or 4 other entities that serve homeless populations, whether it be people with addiction or people fighting other mental health issues. So the city is contributing what they can to those agencies. Those agencies also have access to state dollars, but the Salvation Army can't physically add any more beds right now. They would love to if they could, but they can't. So you have some capacity issues that aren't completely within the city's control. You also have the Sheboygan Housing Authority, and they manage Section 8 vouchers, and we're aware that they're not using all their Section 8 vouchers right now. So that is also an issue that we can't control. We have a close working relationship with Partners for Community Development, who does great work in this community to rehab blighted homes and get them decent, safe, and sanitary for low-income people. We're doing as much as we possibly can with the dollars that we have. So I mentioned that of this $910,000 a year, the city, by federal law, can only spend 15% on these public services, so giving money to the Salvation Army, the Abode, the warming shelter, different places that help people. We also have the capacity to use the other 85% of the money. 20% can go into admin, and the other percentage can be used for a variety of things, but it all has to help low to moderate income people. And we're coming up with our consolidated plan, which is the 5-year plan, and there will be a public hearing, I would think sometime either late June or July, early July, for how we're going to spend that money for the next 5 years. In addition to the 5-year consolidated plan that we're working on right now, there's always every year there's an annual action plan that follows the same process of a public hearing and how those annual dollars get programmed. So we make a guess over 5 years how we're going to spend the money, and then each year we get to hone that guess a little bit more refined, and there's always a public hearing every year. Nobody usually attends, so it would be great to see. I mean, I joke that when I retire, I'm just going to go around and attend public hearings and comment on these people's consolidated plans because nobody ever does. The other joke we have is when it is that day, I always say, fire up the margarita machine because we got to wait, we got to serve these people that are coming to this meeting, and nobody ever comes. So that's a joke. We'd love to have public comment on these plans to spend these federal dollars, but we're trying to do the best we can with that money.
Just another follow-up, sorry. So in addition to that work, council recently departed with some kind of remnant land that the city had, and we've kind of taken it on to try finding as many lots as the city owns remnant lots. So to Brian's point of infill development, and working with Habitat for Humanity on turning those lots over so they would develop them. And working with them, they think they can get about 5 houses a year. So our goal is to try finding about 5 lots and work with them to get that type of housing available as well. So we're trying to address at one time every single income level. We've got a couple different projects that are subsidized using some of the vouchers. We've got other projects that are hitting more of that affordable, that missing middle, and then we've got a couple different market rate projects that are going as well. So we need every type of housing, and I understand not every project is going to hit that income level, but there is a substantial demand at every income level right now. And the more we can get filled, that'll free up other areas and hopefully other types of housing that will backfill quickly.
Okay, so I guess my follow-up question would be, out of the 21 lots, there's going to be $400,000 houses. What's the low end of that? And also, what's going to keep people from buying those houses? 3 out of the 4 corners look right at the lake. What's going to keep people from buying those houses and turning them into Airbnbs and taking away the housing that you're trying to create? So I need the low end of the house point, and what's going to keep people from reducing housing instead of increasing it?
I can't speak to the price point because that's the developer's decision. To be honest with you, they have a guaranteed value that they'll have to meet, and so we can project X dollar per lot, per house. But as to what they'll charge or what the sale price will be, I couldn't tell you. But we live in a free society where people own land and they have the right to do what they want with their land. And just like you can do what you want to do with your house, if they turn it into Airbnb, unless there's some land restriction or covenant on the property saying they can't do that, they have every right to. And so if that's part of the development agreement, that's part of the development agreement. But otherwise, it's just like everyone else doing whatever they can do legally with their land.
So it's commercial, not residential. Got it.
Okay, we have one last speaker for the night, and I'm not sure the name. I think it's Frey, F-R-E-Y-E. Sorry.
I hear all of you talking. I hear that there's consent among all of you. I hear that the city is completely transparent. I hear that Sheboygan County Economic Development, DUDA is doing its job. But I also agree that the occupancy rate in the homes has to be studied because that's tax-based. And if you don't know the exact occupancy rate, you aren't going to be able to finance anything more than that TID. Second is that project means tested? And that's simple, like Taylor should means tested. And then finally is you're doing a great job being here. We should compliment the director, Emily, for hosting this, to reaching out to the community. This is a great place to go for the elderly like me. And Emily's sitting there, and she created this along with the board, like Penensky, you guys. So compliment Emily. Thank you.
Alrighty, seeing as it is 8:27 and the meeting will end no later than 8:30, I will be looking for a motion to adjourn. All in favor of adjournment? Aye. Chair votes aye. We're adjourned at 8:27.